distinguished members of the court. My name is Christine Van Guyen, and I represent the prosecution in this case. My co-counsel, Jeremy Barretto, will be doing the reply. In the 1930s, Adolf Hitler threatened to exterminate the Jews and the Roma, and no one acted. In the 1990s, Serbian President Slobodan Milosevic threatened to ethnically cleanse Greater Serbia, and no one acted. In 1994, General Romeo Dallaire warned of Hutu threats to destroy the Tutsis in Rwanda, and no one acted. On February 2nd, 2007, MBAN President Robert Turk threatened to destroy Tuba and its population. The time has come to act. President Turk returned home to Emba and made subsequent speeches comparing Tuba to a cancer in the region. Based on these words, this court issued a warrant for his arrest. When he stepped foot on the territory of Roost, a party to this statute, he was arrested. He's been surrendered to this court. The interview that he gave to Miranda Phoenix is very relevant to this issue. The prosecutor has entered a voluntary agreement for her testimony. There are 34 victims who suffered emotional harm based on fear arising out of these threats. The prosecution is making 4 submissions. First, that the court has jurisdiction. Second, that the arrest in Roost was not only permitted by international law, it was required by international law. Third, that in order to fully adjudicate on these issues, the testimony and evidence of Miranda Phoenix must be admitted as evidence. And finally, victims K1 through 34 have suffered harm and should be permitted to participate in these proceedings. Let me begin with the issue of jurisdiction. The court has jurisdiction and should confirm the charges. Article 61 of the Rome Statute states that there must be sufficient evidence to establish substantial grounds that the accused committed a crime within the jurisdiction of the court. The al-Bashir decision from only 2 weeks ago confirmed that this is a low threshold, less than beyond a reasonable doubt. As stated in the Lubanga decision from January 29, 2007, what is required is a concrete and tangible proof demonstrating a clear line of reasoning underpinning specific allegations. The prosecution will show that this threshold has been met. With regards to jurisdiction, there is both territorial jurisdiction and there is subject matter jurisdiction. There's territorial jurisdiction because the offense occurred in Tonda. I direct Your Honor's attention to Article 12(2)(a) of the Rome Statute. The court may exercise jurisdiction if the state on the territory of which the conduct in question occurred is a state party. The word conduct appears infrequently in the Rome Statute, and it is distinct from the word crime. At a minimum, conduct is the speaking of the words with the knowledge that Miranda Phoenix would publish those words in Tonda. The conduct applies to any act leading up to and including that publication. Because that publication did occur in a state party, Tonda, there is jurisdiction through to 12(2)(a). The prosecution emphatically submits that this should be the basis of jurisdiction. However, in the alternative, the court could create a narrow extension of conduct to include the effects doctrine, objective territoriality. This is an accepted principle of international law. It's been applied in cases like the SS Lotus, Noriega, and Charles Taylor's case. The effect of President Turk speaking to Miranda Phoenix was the publication of those words in the territory of a state party. This satisfies Article 12(2)(a). I will now address subject matter jurisdiction. There's subject matter jurisdiction because incitement to commit genocide is a crime under the Rome Statute. It's criminalized in Article 25(3)(e) of the statute. Its inclusion in the statute demonstrates a clear intention by the drafters to criminalize incitement alone as a standalone crime. However, its inclusion in Article 25, which governs modes of criminal responsibility, rather than Article 6, genocide, may suggest to the court some ambiguity. The prosecution submits that there should be a two-pronged approach to rectifying this ambiguity, to clarifying it. First, Article 21b tells the court to apply principles of international law. And second, Article 32 of the Vienna Convention tells the court we can look at the work of the Preparatory Committee. The baseline principle of international law is that incitement is a standalone offense. It's criminalized alone in Article 3c of the Genocide Convention, and Article 4c of the ICTY statute, and Article 2c of the ICTR statute. If the drafters had intended to depart from this baseline principle, there undoubtedly would have been debate about it at the Travaux. There was in fact no debate about moving the article, and its movement has been described in the academic literature, for example, the Davies article cited in my memorial, as a matter of housekeeping. Moreover, the German delegate to the Preparatory Committee, Kai Ambos, has stated incitement is unquestionably a standalone crime. Furthermore, the ICTR Appeals Chamber, in the Nahimana decision, gave a comment on its interpretation of the Rome Statute. In footnote 16 and 15 of the Nahimana decision, an incitement case from Rwanda, the appeals chamber that stated that incitement appears to be an in-quake crime under the Rome Statute. This is because Article 25c, which governs solicitations and orders, deals only with crimes which, to quote the statute, actually occur or are attempted. Since the drafters were alive to this difference in language and elected not to include it in 25e, demonstrates that this is a standalone crime. The material elements of this crime have been established. We should consider exactly what it was the president said. He said the only solution to the ongoing dispute was the full destruction of Tuba and its population. He said that this destruction would be the greatest achievement in history. And he called on others, leaders in the nation, in the world, and in the region to join him in achieving this destruction. These words satisfy the four material elements of incitement to commit genocide. These elements are defined in the Akaisu decision from the ICTR and also in the Mujasera case from Canada. There are four material elements. First, there's incitement and it's to genocide. Second, the incitement is public. Third, it's direct. And fourth, that the accused has the required mens rea. The act proposed by President Turf would unquestionably be genocide. If I could direct Your Honor's attention to Article 6 of the Rome Statute. Genocide is defined as a series of acts, the first of which includes willful killing, committed with intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. President Turf has called for the destruction of the national group of Tuba. This would be genocide. He called on others to commit it with him. He called on other leaders in the region and the world. He prompted, provoked, or encouraged, to use the language of Akaisu, another to commit a crime. This is the definition of incitement.
I'm sorry if I may interrupt. You say that the incitement was for the destruction of the national group?
It was the destruction of Tuba as a national group.
Can you elucidate on what you mean by national group?
Tuba is a state, and the people who live in Tuba is a national group. However, there is an Emden minority which lives in Tuba. This call for genocide could be either along national lines or along ethnic lines. The prosecution concedes that it's unlikely that in his call for genocide, the Emden president meant to include the Emden minority living within the borders of Tuba. Because there is a dispute about self-determination in this area, and because the idea of the state within